My name is Jacqueline Bhabha, and I'm very pleased to be moderating this session 6. I always think it's a compliment when you have a after-lunch event. They always put the people who they think are the most interesting and the most sparkling, so that's us. So just a couple of general announcements to remind you. When we get to the Q&A, please switch on your mic if you want to speak, and switch it off once you've spoken. And if anybody from that side of the room wants to leave, please, or in general, if people want to leave, just please go behind the filming person so that we don't interfere with the image. So our session today is on legal frameworks and protection of identities, and we actually, at least the sessions I've been in so far, we've not talked very much about legal human rights issues, so I think it's most appropriate that we have a session on that. I'm going to invite my 4 panelists to speak in the order in which they're listed in the program, and each of them will have a maximum of 15 minutes so that we have half an hour for discussion at the end. So we're going to start with Srdjan Mrkić, who is the chief of the statistics division in the UN, and we're going to follow his presentation with a presentation by Setel, who is the vice president and director of an organization called Vital Strategies that deals with registration and civil statistics. And then Philip's going to be followed by Claire Brolan, who's an academic who teaches at the University of Toronto, is an expert on public law and in particular health-related and public health-related issues. And finally, we're going to end with Zoran Đoković, who is an advisor on questions of identity and freedom of movement and works for the OSCE and for within that for the division of international human rights. So we have a very mixed panel of a UN official, a civil society representative, a regional organizational representative, and an academic. So I think we're in for an interesting discussion. So, Srdjan, over to you.
Thank you very much, Jacqueline. Can I have the... Oh, thank you very much. Good afternoon. I hope that we will make good use of the time that we have ahead of us to discuss the issues concerning the legal framework for civil registration, vital statistics, and identity management. As we have already concluded, I would suppose this morning that the holistic approach to these 3 functions is the way to go. In that case, we are also in the need to look at the legal framework that will tackle all those 3 functions in a harmonized and holistic manner as well. In that context, what I'm going to present here is a part of one of the handbooks that we have produced as an accompanying volume to the International Standards for Civil Registration of Vital Statistics. There is a handbook that is entitled The Legal Framework for Civil Registration and Vital Statistics, which has been put together back at the beginning of the century, to be more precise in the previous century, in 1998. And is now being revised with the kind assistance and cooperation from Brolan Philanthropies that we are working together on the revision of the legal framework. So what I'm going to present here is a mix of what already exists and could be perused by anyone that accesses the handbook on the legal framework for civil registration and vital statistics, but also contains some of the new points that will be covered in the revised version of the handbook on legal framework. So. Thank you. Let me just start with very briefly putting a kind of a general comment on the existing legal practices in the world. In most countries in the world, we would have a constitution. At the top of the hierarchy, of the legal framework hierarchy, the constitution, of course, is the highest act of the land. It is very generic in nature. as it has to be, because all of those provisions that the Constitution essentially covers are tackling the major concepts, such as the borders, such as the defense, the foreign affairs, the individual rights, citizenship. So a kind of broad topics that fall under the highest act of legal act of the land. Out of the Constitution, we do have the next hierarchy level, which refers to the laws, which are derived from the constitutions. And in a very general, again, terms, we have two kinds of laws. Laws that are substantive in nature and laws that are procedural in nature. When we say substantive in nature, that means that the law regulates certain aspects of the functioning of the society, such as the criminal law. So the criminal law will define what is a crime, and will define what is the punishment for the crime, and all of the other components of a criminal behavior. However, if we look at the procedural law, we will have, for example, the law on criminal procedure, which will not debate about the occurrence of a crime, but will certainly debate in very minute details about the prosecution rights and responsibilities, about the jail time, for example, and what are the processes involved in going through the law enforcement system. So another example of the substantive law is the family law. This is the law that would then regulate the family affairs, such as marriages, such as divorces, adoptions, and other of the relevant events in the life of an individual. So when we talk about the laws that we are going to discuss here, we are talking about the procedural law, which is the civil registration law. The civil registration law is not supposed to discuss about the issues that are such as what is a marriage. Can there be a same-sex marriage? But they will define how the marriage is registered and what are the responsibilities of each of the actors in the nuptiality process. Finally, in the lowest level of the so-called legal tree, we would have the regulations. The laws are, of course, enacted by the parliament. The regulations are enacted by the government. That makes them much more flexible. The government can then issue the regulations in a more speedy manner. Debating a law may take an extended period of time. So the regulations are used to make the laws more specific. For example, you may have in the provision of the law that whoever speeds will be fined, but the amount of the fine will then be dedicated through the regulations. When we look at the civil registration legislation, so as I've said, we have three components here. We have the civil registration, we have the vital statistics, and we have the identity management. So we will go through the legal framework for each. When we look at the principles for civil registration legislation, the first principle is that of the legality, which means that the civil registration has to reflect the reality. The events that are occurred, once their registers are becoming legally valid. Otherwise, they did not exist from the legal point of view. The protecting interests of the individual is the second principle. The law has to protect the individual, providing ready access to the services, the full information of procedures and outcomes. Also, the principles of official status. The law must give the registration agency the power and authority to promote registration. Registration has to be compulsory. We mentioned that this morning when we were talking about the four principles of civil registration. One of those four principles is that it has to be mandatory. It has the principle of the legislation should be that it should be simple and to understand, and the simplification of the service. And, of course, one of the major provisions of the law is that the service has to be free. If you look at the general provisions of such a model law that actually is part of the handbook on the legal framework that I mentioned initially, we would need to have definitions of vital events. We do have those definitions listed in the principles and recommendations. These are the internationally agreed definitions of what is a birth, what is a death, and so on. The general provisions would make the registration compulsory, would make the collection of statistical items mandatory, would make sure to protect the privacy, has to regulate access and safekeeping of the records, and the storage and preservation of the records. So these are, when you look at the law, you would have the general provisions, so that would be the general provisions of the law. Specifically, it would also need to have a description of the registration infrastructure, who is in charge of registration, what are the authority, the responsibility of the chief registrar, the local registrar, the registration units, and so on and so forth, the notifiers, informants, and other in the chain of the reporting of occurrence of the vital event. Then the law should also regulate what is the proof of registration. So we are talking now about different certificates that are being issued of by the civil registrar. It has also to regulate statistical reports, who is responsible for collecting the information that is necessary for the production of comprehensive and reliable vital statistics, what are the protocols for transmitting this information to the National Statistical Office, what are the deadlines, who is supposed to do what. All of this has to be part of the report. Inspection and penalties. Quality assurance is critical. If you want a civil registration to function, there needs to be an oversight. And that is why inspection takes a very prominent spot when it comes to the defining it in the law, who has the right to inspect, and what kind of inspection is authorized. And finally, and pretty importantly, the funding. We, in the principles and recommendations, the international standard, claims the ownership of the civil registration system to be on the government side. So the government has to fund the civil registration activities. And this has to be regulated and outlined in the civil registration law. So again, in the context of the new holistic approach for the civil registration, vital statistics, and identity management, we did mention that we need to, the law has to have protocols for transferring data to the population register and ID management. In the model that have been presented this morning, the interlocutor between the civil registration system and the ID management system is usually a population register. We have heard also before lunch the presentation from Norway that shows quite, I would say literally, how this functions. So you have a population register that is a major vehicle that transcends both the civil registration and the identity management system, ensuring that the services rendered to the citizenry are coming from the same structure and with the same components. Ensuring confidentiality, security procedures, authorization, access to records, deadlines, and frequency. So these are all the part that has to be the part of the civil registration law that regulates how the individual information collected by the civil registration administration ends up in the population register and who is essentially doing what in that case. Now, the legal framework for identity management does not, at this point of time yet, have a kind of international standard. The international standards for identity are still in the works. And thus, we cannot, as we do have the standards for civil registration, we do have international standards for vital statistics, we cannot claim that we do have such standards for identity management at this point of time. However, we do have a number of national examples and how it is done and what is the pieces that have to be put in place in order to make sure that the legal framework enables the holistic approach to these three functions. So the law would have to have the designated agency, which is tasked with managing identities, and also what is very important as a major piece of the new identity identification documents is linked to biometrics. There needs to be a clear authority by the agency that they can collect biometrics from people in the country. And what kind of biometrics and what is the cycle of collecting of biometrics? Is there any kind of updates and so on and so forth? Very important are the protocols for data sharing. We have seen, again, in the example of Norway, how one information that is on the population register is shared by many. However, how it is shared, what kind of piece of information is shared, who has access to that shared information, because these are individual records, has to be spelled out in the law clearly. Security procedures, confidentiality and privacy, this is, again, major concern. Yes, if we look back at some of us, we still remember those very thick telephone books that you could find in any city in the world, where you would have the name, you would have the address. So those are, let's say, to a certain extent, we can interpret it as being public records. However, in today's world, where the sensibility to the breach of privacy is so accentuated, it is really a critical importance to have this regulated in the law with a clear understanding who is doing what. The document content, this is also very important. What is that document going to contain? We do have some national practices that put, for example, the religion on the ID card. And this is something that has to have a kind of clear rationale, and that rationale has to be spelled out in the law. As I've said, at this point of time, we still do not have kind of international standards to guide us. And we are working on it, and hopefully they will be available sooner rather than later. But right now, it is important to emphasize, to outline some of these issues that should be dealt with in the context of the legislative framework for these three holistic functions. A very important piece, next to the last, that I would like to also emphasize is that the legal framework for civil registration, vital statistics, and identity management does not stop at the national level. It goes well beyond the national level, and it is really the United Nations that focuses from the very beginning on establishing, promoting, and implementing human rights. And the human rights do fall under the international law. So in that context, United Nations emphasizes that the role played by civil registration in proving and establishing, implementing, and realizing many of the human rights embodied in the international declarations and conventions is one of the most important contributions to the functioning of contemporary societies, which means it's not only the national law that matters. What matters is international law as well, that spells out the human rights that have direct impact on the status of each individual, and that is coming out of the availability of civil registration or the lack of it. So I am just emphasizing a few of those. The list is extremely long. Mm-hmm. So if the country signed any of these conventions that you see here on the screen, in that case, that convention becomes a part of the legal framework for civil registration, vital statistics, and identity management. So this is just to say that we don't stop at the national level and say, okay, now we have the legal framework here, and it is very well nice put in place, and we have all the components, but we have to look beyond it. We have to look at the international law. We have to look at the human rights and see how those regulate, for example, the right of child to a name, which is clear, as we all know, the Article 7 on the Convention on the Rights of the Child. If the country signed the convention, it has to provide a means that each child is assigned a name upon birth, which means that the child is registered and the birth certificate issued. Thank you.
Very much, Srdjan. That was actually an excellent start, I think, outlining so clearly both the connections between the different organs within a government that are responsible for these three different branches of civil registration, vital statistics, and identity management, but then also the kind of nesting of domestic, regional, and international systems that compound this. So I think this is a very good basis for starting this conversation. Thank you. Our second presenter is Philip Setel from Vital Strategies. So Philip, over to you. Thank you.
Thank you. Thanks, everyone. Good afternoon. This morning we heard about the need for doing the fundamentals right from John Grove. And we also heard from our colleague from Cameroon about making the invisible visible. And just now we've heard a really great presentation that talks about the structure, purpose, and some of the components of a proper legal framework for CRVS. But how do we know we've got a good one in terms of a legal framework? And how do we get from the current state to the desired future reality? I'm going to talk a little bit about, briefly touch on the importance of legal frameworks, which I think have been well covered already by Srdjan, and what a good legal framework might look like, the tool and the process that the Bloomberg Philanthropies Data for Health Initiative and Vital Strategies have developed in order to assess the situation, and the process by which it is applied, followed by some country examples. So I'll take you quickly through this. A well-conceived legal framework, the main point here is that it's a necessary but not sufficient requirement for eliminating barriers and creating incentives to civil registration, and particularly the registration of births and deaths, but other vital events as well. Doing so gives all kinds of benefits for society, development partners, and others, as well as for individuals. A legal review can and should be undertaken in order to see whether or not the structure of that legal framework enables, inhibits, or leaves unspoken best practices around civil registration and vital statistics, and is one that enables good business process, efficient operation of the CRVS system. A legal framework should clearly define the responsibilities, the powers and functions of the stakeholders, balance specificity and clarity with enough flexibility to respond to change, and ensure that relationships and processes among stakeholders are authorized and required even. So a good legal framework is really the skeleton around which a well-functioning CRVS is built. Of course, it is not sufficient in its own right to guarantee that, but it is a necessary starting point. It's one of those fundamentals that John Grove spoke about this morning. Its best way to ensure that mandates for universality, permanence, and continuity of coverage is ensured. And it is a significant tool for increasing efficiency, security of, and demand for CRVS services. So that's sort of the setup. The tool that we have developed, which we call a legal and regulatory review, came out of this desire to understand the degree to which existing legal frameworks in the countries within the Data for Health initiative initially, but it's globally applicable, do in fact accomplish or enable or discourage or are agnostic about the key things that make up a best practice 21st century CRVS system. We regard it as part of a rigorous assessment overall of a CRVS system together with business process mapping, that's what BPM stand for, and Anaconda, which in our case is a tool that is not a snake. It's a tool that is used to analyze the quality of cause of death data. So we have a technical package, if you will, of assessment resources that include legal and regulatory review. It's designed to be completed by local lawyers with a range of knowledge, and some of them have no knowledge of CRVS, in partnership with other stakeholders at the country level. The ultimate audience is the heads of agencies and ministerial authorities who have the ability to make structural changes based on the recommendations that come out of the assessment process. The tool is sort of a matrix. It consists of 8 chapters with 42 best practices. These are derived from, of course, the principles and recommendations of UNSD, as well as consultation with registrars from around the world. It's a guided sort of survey and inventory of the laws and regulations and standard operating procedures for the given country, and it is designed in a modular way with a PDF form that can be filled in as you go along. It covers laws, regulations, and it gets down even to standard operating procedures to see that there's a line of sight from those standard operating procedures through to the regulatory and legal framework to the best practices that are ideally in place. And it's used to identify where there are gaps and opportunities for change. The way we have implemented it is to first seek government sponsorship, and we tried to get as high government sponsorship as possible from the CRVS steering committee, if there is one, which is usually chaired by fairly senior officials even in the Prime Minister's office, but it's usually an interministerial commission. We put together a legal team. Again, this is not fly-in, fly-out technical assistance. We look for and assemble a team of local lawyers. There's a kickoff legal workshop with all the stakeholders. We then ask the lawyers to gather all the relevant laws, regulations, and standard operating procedures. They then complete the matrix. We regroup with stakeholders to share the results of the completed matrix and brainstorm workarounds. The hardest thing to do is change the law. So if there are adjustments that need to be made, we try to accomplish that through changes in standard operating procedures or regulations that can be in the form of a ministerial letter or an order rather than a change to the law. And there is drafting and advocacy support available to help implement the agreed-upon improvements. So there's a potential range of outcomes from this review that range from leaving things as they are, because if they aren't broken, we don't attempt to fix them, to changes to internal procedures, all the way through new CRVS regulations or even very fundamental birth and death acts, some of which, as we heard in the previous panel, are the legacy of the colonial era, particularly in sub-Saharan Africa. We've been working to apply this tool around the world, and there's one country missing. We're planning on now doing this in Bangladesh as well. But the Data for Health initiative has been working in the countries that you see on the map to implement this tool. And it's proven very, very popular, I must say. Our progress in the past year, we've completed application in Ghana and Rwanda and Tanzania, and we are on track to complete the work in about 7 or 8 more countries. Now I want to talk about, just briefly, some examples of the kinds of results that have come out of this legal and regulatory review. One pertains to the exchange of data between ministries. I know there is a very well-off country in sub-Saharan Africa, which shall remain nameless, that had a situation where the data could go into the CRVS system but couldn't come out. Similarly, in Ghana, there was no agreement to actually govern the sharing of data between the Ghana Health Service, which had so much information about vital events, and the Births and Deaths Registry. So that was a finding that popped out immediately, and there's now a memorandum of understanding between the Ghana Health Service and the Births and Deaths Registry to permit those data to flow. In Tanzania, the whole Births and Deaths Act has been overhauled. It's currently in parliamentary process. It's in cabinet review at the moment, and it's expected to go to Parliament in the not-too-distant future. In Rwanda, which utilized the toolkit independently without technical assistance from Vital Strategies or the Data for Health initiative, there are several results that have emerged, including the authorization of health facilities to act as official registration points, give them official status to legitimately notify and declare vital events, authorizing healthcare workers who interact with the community to be legitimate vital events notifiers, to define multi-stakeholder coordination for CRVS under one authority and reduce the fragmentation, and to define, again, data sharing and systems integration among the stakeholders. So these were completely homegrown solutions to problems that were realized through the course of applying this legal and regulatory review. The Philippines is another country where we have recently completed the work. And just this morning I was looking at a commitment on the part of this National CRVS Steering Committee to take on board the recommendations of the workshop and to ensure that the host of recommendations that came out of the review activity are followed up in the quarterly meetings of the CRVS committee. But already there are improved guidelines for the medical certification of cause of death. That's our McCOD. It's not a fish sandwich from McDonald's. It's a medical certification of cause of death. And compulsory MCCOD training in medical school curricula has been added. And in Colombia, we have uncovered a wealth of CRVS regulations, and the realization there is that these all needed to be consolidated, that there was chaos and confusion in the regulatory sphere, and that there needed to be a streamlining and consolidation of the guidance and regulations that govern CRVS implementation in the country. I won't go through these because I'm sure I'm running out of time, but you can briefly... 2 minutes? 3 minutes. Oh, I'm not running out of time. I'm almost done. In Cambodia, we're working to amend the whole legal framework for the integration of CRVS and NID systems. In Brazil, we're working on regulations that permit electronic death certification and improve coordination with legal medicine. We find that in some countries, the laws specify that the thing has to be on paper, for example, which leaves out digitization. They specify an old form of the medical certificate of cause of death, which leaves out the ability to upgrade to ICD-compliant causes of death certificates and so forth. And Ecuador, Peru, and Zambia, you can have a look for yourselves, the kinds of work that is flowing from the legal and regulatory review. I'll say that these are skewed towards things like cause of death and so on because that happens to be the remit of the Data for Health initiative. But there are other results that can and should be highlighted that pertain to other sectors as well. Excuse me. The toolkit and data will be available shortly at that website. And in a second edition, we will be working on including other vital events, the integration with NID systems, data security and authentication, cross-border issues, and I'm going to add in the human rights that are enshrined in any conventions that the country happens to be a signatory to. And I believe that, for me, one of the standout questions here is the ambiguity between CRVS and national ID systems. And if it's not too abstract, my own way of thinking about this is that CRVS provides proof of legal identity, but NID provides legal proof of identity. The idea being that you need your birth certificate to prove that you have a legal identity and standing in a given country, and that the ID card or the ID number that you carry around with you is acknowledged by government services as being legal proof of your identity. So I'd be very interested to hear if that's an idea that resonates with people, and if there is also perception around the room that NID operating in a fairly legal and regulatory gray zone can actually pose some risks to the CRVS system and to its smooth functioning. So I will end there. Thank you very much.
Philip, thank you. That was a fabulous presentation. I think the way in which you outlined both the need for a legal framework, but also then a follow-through into how that legal framework works on the ground with the examples that you gave. I think that's often that second step is something that lawyers miss, and with very negative results. So I think this is fascinating, and I hope in the discussion we can actually pick up your very, I think, stimulating final point about the relationship between CRVS proof of legal identity and national identification systems as legal proof of identity. It's actually a really interesting idea. So thank you very much for that. Our third presentation is going to come from Claire Brolan, who, as I said, is an academic who teaches and researches at the University of Toronto and is an expert on public law and public health systems and matters of human rights. So, Claire, over to you.
I'll just get the clicker before I start. Oh, great. Thank you. Okay. Well, good afternoon, everyone, and thank you, Jacqueline, for that kind introduction, and my sincere thanks to you, Irina, and to the Centre for Excellence for inviting me. Okay. So the thinking underscoring my presentation today is very much informed not only by my professional experience, but by a number of papers I've researched and published over the recent years on cross-cutting issues, such as those on the screen. And I'd really like to take this opportunity to obviously acknowledge my co-authors, particularly Dr. Hebe Gouda from the World Health Organization, Dr. Lisa Foreman from the Dalla Lana School of Public Health, and Dr. Peter Hill from the School of Public Health at the University of Queensland in Brisbane, Australia. My presentation today is at the intersection of four ever-evolving, complex and expansive topics: international law, the sub-branch of international human rights law, CRVS, the 2030 agenda, or I should say plural, agendas, and emergency, conflict and disaster settings and contexts. So as you can imagine, filtering and narrowing down the content of my presentation has been somewhat epic, so please forgive any and all brevity. For instance, when I refer to emergency, conflict and disaster, or ECD settings, I'm going to take a very broad brushstroke approach. I only have 15 minutes, and the confusing minutiae of definitions, for the purposes of this talk, doesn't really interest me. What interests me, however, is that ECDs occur and will continue to occur in all countries and in all regions, and they are multi-causal. What really interests me is that in ECD contexts, the actors, institutes and interests involved and questions of power are multifaceted and complicated, and that's an understatement. And what really, really interests me about ECD events is that these events usually are unfeeling of sovereign borders, care little as to whether the person, family or community members they devastate hold identification documents or are registered in civil registration systems. And all too often their gravest impact is on the poor, the marginalised, including the geographically isolated, the most people living in the most remote locations, the discriminated and or the undocumented. And in my view, unless there is accountability in the 2030 agenda rollout by countries toward these people within their borders through express provision, let me repeat, express provision in sound legal and regulatory frameworks for CVS, which is something I think all countries must relentlessly strive toward in the next 12 years. My fear is that it will be these people, particularly undocumented women and girls, persons with disabilities, Indigenous persons, minorities in hard-to-reach locations, who I believe will fall between the SDG cracks and be the nobodies left behind in the year 2030. So on that sobering note, let's go to the disconnect. For some time, the power, potency and imperative of death registration, certification and notification to protect and promote human rights, not only in ECD settings, but in international development settings more broadly, has really been underappreciated. And I think an understanding of how this underappreciation, how this disconnect came about in recent history is important. So just very briefly today, the thinking behind the construction of the 8 MDGs has much to answer for. And that really, the MDGs very much put rights and development on separate trajectories. And Philip Alston, in this wonderful 2005 article, described development and rights in the context of the MDG rollout as ships passing in the night. Secondly, add on to this the fact that when countries and their bilateral, multilateral partners then went on to interpret country commitments under the MDG goals, targets and indicators, with now human rights aside and asunder, the MDG framework was mainly viewed by these actors as an international development framework to be applied solely in and to developing countries and somewhat implicitly the development needs of the citizens of those countries. So this in turn meant that countries did not prioritise in their MDG policy, planning or implementation efforts the inclusion and counting of non-citizens or highly vulnerable persons such as displaced or stateless persons or marginalised minorities. And for many countries, these segments of the population within country borders were too hard to count. They did not provide countries quick, easy MDG metrics gains. They weren't the low-hanging fruit for MDG achievement, and so they were routinely overlooked in MDG measurement. And of course, often these segments of the population have surrounding political sensitivities. And often just looking at issues that affect them, one wades into somewhat of a political quagmire. So for some countries, it was politically expedient to have known unknowns or unknown unknowns. Mm-hmm. Subsequently, many of these individuals and communities, as a matter of course, became invisible in country MDG plans and reporting frameworks and metrics. And for example, the UNHCR High Commissioner in June 2005 emphasised that national MDG strategies seldom referred to displaced persons, and this was a key point to be advanced. But with all due respect, I have to say that the population health research community was doing some great advocacy for CRVS systems strengthening as the MDGs rolled out, particularly because they were engaged in the rollout of MDGs 4, 5 and 6, three of the 8 MDGs related to health. And so within the population health community, there was a strong understanding of the importance, I think, of health information systems to produce good data for MDG measurement and broader national health policy and planning initiatives. On the other side of the fence, we have, when I look at the international law and development literature, that's also very siloed. And at this very same time, as the MDGs were rolled out, those particular academics were looking at birth registration. So the focus was in no way on death registration. The focus was on birth registration. And I think there's a number of reasons for this. UNICEF was very much involved in promoting birth registration in this period. We had the wonderful work of Plan International as well. But I think the key reason there was traction among human rights scholars and advocates was because birth registration and the focus on birth registration has unequivocal international legal mandate. The right to name, nationality, the right to know and be cared for by parents, the right of the child to preserve his or her identity, that every child should be registered immediately after birth without discrimination. These rights are enshrined in Article 7, Article 8 of the Convention on the Rights of the Child, Article 24 of the International Covenant on Civil and Political Rights, among a whole host of other UN conventions, such as the Convention on the Rights of Persons with Disabilities, UNSD, and really key regional human rights treaties. So suffice to say, death registration and certification, on the other hand, is not implicitly or explicitly entrenched in hard international law and causally linked to identification and ID rights in a UN convention that the massive UN member states have signed up to, in the same way that birth registration is and has. And because of the dislocation between death registration and certification from international human rights law, death registration is not ordinarily or strategically seen or treated as an identification and human rights issue, but it is. So why and how does death registration fall within the ambit of international health rights, of international human rights? At the very heart of international human rights law is this concept of human dignity, protecting and promoting human dignity. And in my perspective, accurate death registration, certification and notification acknowledges the human dignity, the existence of the deceased person, and it also causally allows and invests in and acknowledges the human dignity of the survivors and the next of kin and the family members, vicariously and causally, of the deceased. In post-emergency settings, where access to health, housing and other welfare supports and resources is crucial for the survivors, benefits flowing from death certification and notification and robust, resilient, adaptive CRVS systems that can withstand sudden in-country pressures and changes, such as those caused by ECDs, can have enormous ramification on rebuilding the lives of communities and families who can benefit from the legal rights and entitlements they are owed by law on the deceased passing in the short and longer term. And this is very much a gendered issue. For example, women who are displaced, who are poor, who are highly vulnerable, the holding of a death certificate, that being that of a husband, a father, a brother or uncle, or the death of a loved one or male relative being in the proverbial civil registration system, might be the evidentiary proof they need in their communities to seek access to inheritance and property rights and entitlements, to access subsidised housing, healthcare, medicines, to access microfinance opportunities to rebuild, or to find new sources of enterprise and labour. Or alternatively, the death certificate might be the evidentiary proof they equally need to have a chance at seeking redress or compensation from authorities when their attempts to access rights or entitlements as next of kin are breached or denied, possibly as a mix of gender bias in legal frameworks, corruption, customary law, or gender discriminatory plural legal systems, or a mixture of all of these. Death registration is also important for breathing life into the whole raft of civil, political, economic, social, cultural rights of internally displaced persons and persons who are displaced but have by force or involuntary moved across borders. And you see that more recently in the international law literature focus on the importance of death registration, particularly with respect to this huge movement of people into the EU, and arguments that death registration is really important for the living, for the survivors, to have knowledge of what has happened to their loved ones, to allow the grieving process, and for issues related to the European Convention of Human Rights on notions of a right to a family life. That's all really technical law, international law stuff. I won't go into it. But certainly the qualitative research has shown that knowledge on where a loved one is in that process of separation because of conflict or disaster really very much is key to enabling the resettlement process for survivors and recently arrived refugees. And inversely, how many? 2 minutes. Oh, okay. I better hurry along then. And the importance of a lack of disaggregated data on the victims, which I think was probably, and the importance for this was, I think Nick probably discussed at length in our previous panel earlier this afternoon. This disaggregated data can be a real force, of great evidentiary value for lawyers and other advocates who are trying to hold governments to account, such as civil society organisations. But it's also really important data for governments to prepare, avoid and respond to emergency and crisis settings, and thereby avoid civil, political, economic, social and cultural rights violations. Okay. We need to be also mindful of the crossover between the collection, use and abuse, storage and dissemination of, we've lost it, civil registration and vital statistics data, which was something my colleagues have already pointed on. And we really need to think about this because we know that our global population is on the increase, and we also know that the number of environmental migrants alone predicted by 2050 is enormous. What's really gaining traction for the importance of death registration in international law are sustainable development priorities. If we see the Sendai framework, we're looking at global target A, the need to substantially reduce global disaster mortality by 2030, indicators needing denominator data on death for all people everywhere, and the cross-cutting agenda of this of the content of my speech today within the development goal context. So yes, Philip, I very much support the legal and regulatory tool and framework that you and your colleagues have put forward. I think it's an excellent start, but I think it really needs to be. I think what needs to be done in terms of that is thinking around how do we engage communities and CSOs in developing and preparing and implementing and monitoring implementation of these de jure laws, because they're the ones in de facto reality who are going to be implicated by that. And I think if we take less of a top-down approach to drafting of law on CRVS and linking it to SDG obligations in an ideal world, we take more of a full spectrum approach. There's community ownership and knowledge of the law on CRVS. There's community awareness of their responsibilities, their rights, their obligations. And to me, that's what's really exciting. And also we can, by engaging communities, understand what are some of the incentives for death registration are, what are some of the disincentives, and hopefully integrate that community-based knowledge into, the best law of the land possible. Thank you.
Thank you very much, Claire. Sorry to hurry you along. These are all really rich presentations, and I think we only need to think back to the long history, for example, in Argentina, of the Madres de la Plaza de Mayo, Cinco de Mayo, the disappeared, and that enormous legacy of not knowing what's happened to loved ones, or the claims that people are now making to really track those who drowned in the Mediterranean, to see how critical these issues really are as human rights issues, both in situations of conflict and in situations of mass migration, or for that matter disaster. So thank you very much for raising these questions, and also for raising the question about the relationship between the top down and the bottom up, or people-centered approach to thinking about norm creation, norm development, and norm implementation. Very important issues. Our last speaker, Zoran Đoković, is going to make his presentation now, and he comes to us from the OSCE. So, Zoran, over to you. Thank you.
Thank you very much. Good afternoon, everybody. Especially thank you for IDRC for the invitation. It's really a pleasure to be here. In my presentation today, I will be focusing on the issue of freedom of movement and linkages between freedom of movement and CRVS systems, the issue that is gaining prominence but is rarely being explored and emphasized. And I think with this presentation, I will sort of bring more light onto this important link between these two important aspects. And I will be also looking and giving some information about European experience in the context of legal framework for data protection, because I come from the part of the world where most of the CRV, in fact almost all of the CRVS information, identity data is already in the databases, and actually the main accent right now is how to ensure that this data does not leak outside of the remit defined by the law. So, speaking about freedom of movement, just a quick reminder of the fundamental right as it is described in the Universal Declaration of Human Rights, that everyone has the right to freedom of movement and residence within borders of each state, and that everybody has a right to leave any country, including her own, and to return to his or her own country. Obviously, there are two dimensions of this fundamental right. One is dimension of internal movement, but there is also a dimension of cross-border movement. It needs to be emphasized also that the fundamental rights gives upon the obligation upon the state to protect this right to the individual. And then I highlighted here in this slide everyone, that if a state has obligation to protect the rights of everyone, the state needs to know who this everyone is, each individual person. So, going on to the aspect of internal movement, which means freedom of movement within the state, here I will be focusing primarily on the experience of OSCE participating states. That means Europe, post-Soviet space, also Canada, United States. In some, I would actually say in most of these countries in the OSCE region, there is a legal requirement to register the place of residence. And there is a residence register that is created, run, often is referred to in many instances as population register, and it is the information from this register that the authorities use for planning purposes, for the delivery of services, and to decide how the services will be provided to the community. What the residence register basic aspect or population register with much more information is about is basically linking information from CRVS system, identity data of the person, with address information. And that creates a residence register. If you add any further information about the person, then you run into the realm of, in terms of terminology, population register. So what does this mean? If you are in a residence register, you basically have your right to move freely within the borders of the state will not be limited. But if you have a trouble to being entered and enrolled in the residence register, this is going to have significant effects on your freedom of movement and access to various other services. So what does this mean in reality is that apart from the fact that there are various administrative regulations in place which define on which basis you can register residence in a certain place, if there is no identity data, if you cannot prove your identity, you cannot be in a residence register, which means CRVS produces identity data which allows you to be enrolled in the residence register. So in fact, in the OSCE region, what we are dealing with in ODIHR, in the OSCE, we most often have the situation that people face limitations to freedom of movement because they don't exist. They are legally invisible. They are not enrolled in the civil register. So this is in short highlight about how CRVS influence freedom of movement within the state borders. But what is gaining more prominence lately is the importance of CRVS system in the context of cross-border mobility. And here I ask for your attention in the context of something that we all take for granted, and that is the issue of passport. And passport is, in fact, the most important instrument for facilitation of international travel, because there is this one document that everybody across the globe agrees to its design and trust as a trusted document, which sort of facilitate movements across the borders at the airports or wherever. It is the International Civil Aviation Organizations that has been defining standards for the design and the security of travel documents, and for a very long they've been focusing primarily on the security of the very document and the secure framework for the issuance of the passports. What they have discovered recently is that it's no longer that important how secure passport is, because they have pretty much achieved top-level security of the document itself. What they have realized is that they have very little control on what information, identity information, goes on that document. And they need to trace that information back to this origin. And this is what they call in the TRIP strategy, Traveler Identification Program Strategy from 2013, that the first thing to bear in mind when issuing passport is that you have solid evidence of identity. I dare to say that this translates not only to travel documents, passport, but in the national context, it further translates onto the issuance of national identity cards. You have to work with the credible evidence of identity. And this is where we think that, and our thesis from the very beginning at the OSCE is that CRVS is the most important aspect that provides system that provides sufficient evidence of identity for subsequent issuance of travel documents and identification documents. In 2016, we embarked on an OSCE-wide research on identity management system, national identity management systems, trying to look exclusively into how the participating states are obtaining evidence of identity in the process of issuance of national identity cards and travel documents. And we sort of knew in advance, but we needed the credible data backing from the European and OSCE experience. It is actually the case that all the evidence of identity data comes from the civil registration system, and this is the only trusted system that provides evidence of identity. That means that if you are applying for national ID card, if you're applying for travel document, you are going to be asked as a first thing to provide your birth certificate. But then, because, as I said, I come from a slightly different region where everything is digitized, that is not enough. It is what is emerging in Europe in general is that unlike the national ID cards with biometric identifiers, unlike travel documents with extensive security features all over, this is not the case in the systems of CRVS, and that these certificates issued by civil registration authorities are generally not safe documents and can be easily forged. So what is emerging in the context of identity management, and what we are showing extensively in the book, I will use the opportunity to showcase compendium of good practices in identity management in the OSCE region, is that after we asked all participating states how they are verifying identity in the civil register, they are also telling us, look, we don't trust the paper certificates anymore. For us, it is very important that, and because we have the capability, that we verify that such identity information exists at the very source, at the database. So our little research questionnaire with participating states produced the following feedback, saying that whenever a person is applying for ID, reapplying also, or for a travel document, in 71% of the cases, I'm speaking in 100% of the cases, they will need to produce birth certificate. But in 71% of the cases, this birth certificate will be further verified online, directly into the database, to make sure that nobody is abusing the opportunity through forgery to gain identity that doesn't belong to them. But that doesn't extend only to birth certificate, because one of the most occurring frauds in the identity management is that somebody hijacks the identity of a deceased person who previously never had the identity. The authorities are also looking into records of deceased persons in the civil registration system. So the data shows 68% of the cases. This is done mandatory online verification after reviewing the application. And also because people change identity through marriages, any information submitted in paper format is also further verified online, in this particular case, in 49% of the cases in the civil registration records. I draw your attention again to this publication because what Philip was saying earlier, and that is that without CRVS you cannot speak about identification. I want to say that there is a wealth of evidence from the experience of quite a number of states in Europe, former Soviet states, again North America, which indicates that when it comes to that region, this link is inseparable. And when it comes to identity management, civil registration, CRVS systems, and civil identification work as a one big holistic system. Now on to the next. Now on to the next topic, as I said many times so far, and that is that everything is digitized in Europe, and especially CRVS data is being digitized, including historical records, but also where this is not the case, there is a significant progress already achieved, and everybody is speaking about interoperability, interconnectivity, and all of these databases are connected. There is an increased concern in the public that this data is going to leak, and then that sort of prompted the great attention to data protection framework for the personal data. So because this is not only civil registration, civil identification, there are many other organizations, many other systems that are processing personal information. Eventually the conclusion, I'm speaking here focusing primarily on European Union, is that there should be umbrella law, which is Data Protection Act, which sort of rule all other legislations, and all other sectoral laws which deal with processing of personal information needs to be in compliance with this general data protection regulation. What this general data protection legislation introduced as umbrella law is that it requires either consent from the data subject or legal basis as a ground for processing of personal information. It also introduced the concept of non-sensitive personal data and sensitive personal data. CRVS data generally does not fall under the EU legislation under the aspect of sensitive data. Sensitive data is political opinion, sexual orientation, also biometric information is being used, and here there is an additional protection being introduced through legislation asking that these processing of such data is further regulated by law and only under specific circumstances. I think this is important aspect, especially speaking when we speak about the context of death registration and health information. Causes of death that is being collected as a process, and how this information and under what circumstances is shared with other actors in the society. So when it comes to the organization, national authority that deals with personal data, let's say this is CRVS authority, there is issue of proportionality that they have to stick with. That means that they will have they should be allowed to process data only for the purposes defined under the law. They should not expand the scope and the purposes for the processing of this information, and they need to limit the access of external body to that information only to the types of information stipulated under the law. As I said, interconnectivity, interoperability under the Data Protection Act requires that all of these data exchanges between various actors is properly regulated, meaning that all actors should be defined, their responsibilities should be defined, and the types of data that can be shared. I also want to concentrate on that data subject, people whose personal information is processed under the data protection legislation. They have the right to access and know what information on them is stored in the system. They have the right to correct this data, and they also have a right, which is important, to know who and for what purposes has been accessing data in the system. Finally, data protection regulation in European experience requires that there is a strong data protection authority put in place which oversees the implementation of this legislation and takes care that through periodic audits that all organizations and authorities that are processing personal information, whether for identification or civil registration purposes, are strictly adhering to the legislation which defines their work. So I hope I didn't take too much of the time. Thank you very much for your attention.
Thank you very much. Thank you very much, Zoran. I think that was also a fantastic presentation, very broad-ranging, but also brought together the different strands of our conversation, and in fact, the conversation we had in the previous panel too, about the relationship between information that's presented and a prior kind of feeder that validates that information. So it's actually a critical set of issues. So we now have, that clock, by the way, is defunct. So we now have just over a quarter of an hour for our discussion. So please identify yourselves and please switch on and off your microphone when you ask your questions. Yeah.
Thank you very much for all the presentations. I think they were very. Thank you very much for the presentations. Very informative. My name is Gloria Mathenge. I would like to follow up on the presentation by Srdjan, and particularly his point around principles around national ID. I think he pointed out that. We do not yet have, if I got it right, we do not yet have international standards on identity management. Now, I am wondering whether we, as CRVS players, are not the home. Are we not refusing to be the home of these principles? And I'm talking about that in relation to the fact that if civil registration is the basis for issuing this legal identity, do we need a separate body to call an identity management authority, or can we not automatically generate legal identities from civil registration data? And in that case, are we not the home of these principles? Should they not be coming from ourselves? And my question is linked to the situation I see in the small islands, where countries have very small populations with struggling civil registration systems, but they are still talking about wanting to create a national identity system. And I don't know, I feel lost in whether we should not be asking them to just generate unique identities from the civil registration system, or we should encourage them to go this way. Thank you.
Thank you. It was an interesting panel with interesting thoughts. One of the things I wanted to ask is, I think there's been a lot of talk about the responsibility of the issuing authorities and what they can use data for and what they cannot use data for. But I think one of the challenges in most of the contexts is that a lot of this data is actually, because of the gaps that exist, held by third parties or other agencies. And to what extent are the laws that are being developed or the frameworks going to address that issue of the fact that data doesn't just sit in the government?
Thank you. Okay, let's answer these two questions. So,
Thank you very much. Thank you, Gloria, for the question. It is indeed a good question, and the answer, unfortunately, is not straightforward. Simply because of the fact that identity has many different dimensions. We can talk about the cultural identity, we can talk about religious identity, we can talk about any kind of other, I would say, characteristics that is peculiar for an individual. What we are trying to address here is the fact that the entry into the legal realm starts with the issuing of the birth certificate, according to the international standards, and it retires with the issuance of the death certificate. So in between, there is a kind of identity that has been recognized by the legal tender that is actually a certificate. Whether that certificate can be used directly for the issuance of the identity management card is now the question of what biometrics play in this arrangement. Because when we talk about the principles for civil registration, we do not mention biometrics. We are not implying that the baby should be taken like they do in quite a few countries. They take the footprint of a baby just to make sure to prevent the trafficking of the newborns and so on and so forth. But this is not in the principles and recommendations. The principles and recommendations say the newborn has a right to be registered right after the birth, and the government has to ensure that. And we do not extend this to the fact whether the baby should have some kind of proof of biometric existence. When I mentioned that there is that at this point of time we do not have a clear international guidelines on what is identity, in terms of, for example, who is the owner of the data that are stored in the population register. If I provide this data, am I the owner, or is it the government? Or perhaps the government is just a custodian, and I am actually the owner. And what the government has the right to do with my data. So all of these issues have to be put before the international community. They have to be put before the United Nations, so that we have some guidelines. What do we consider a kind of no crossing red line? Where do you stop actually your identity, collection of individual identity data? Who has the right to see them? If you have the population register, does the security agency have the access to the population register? And if so, under which conditions? So all of this is, at this point of time, a kind of a gray area. So what we are saying is we know that this system has to be put together. And we know that this is to the benefit because it is cost effective, because it flows one from the other, and more importantly, because you secure 3 points there. You secure the civil registration. That means that everybody has a legal tender related to the existence. You secure the vital statistics, which is critical to assess the phenomena of the population, and you ensure identity document that gives you access to all the services. And that makes sense to put it together. And this is what we are saying. We are working towards it, but we do not have, for this part, still international consensus. If you ask whether the Civil Registration Office should issue identity cards, I believe in my practice, and I've been in quite around, I haven't seen that happening, because this is simply going beyond what the Civil Registration Office would be willing to take a bite of. It comes with a complication. You need to have biometrics, you need to have tracking, you need to have all kind of protective measures to make sure that you are up to the level. So, usually in society, it will be a registrar that gives you a birth certificate. You go to that office, which is usually the police or Ministry of Interior or somebody, or a separate agency, submit your certificate, and then you essentially ask for this ID. So, if it be automatic, you might not wish to have an ID. That is up to your personal, I would say, preference. So this is why, as I'm saying at this point of time, a number of issues are still hanging undetermined when it comes to, as I said, ownership of data, confidentiality, who has access to what part of data. We did have one example in sub-Saharan Africa where, for sharing the data between the police and the population register, they developed an algorithm that would pick bits and pieces of the information and match it with bits and pieces in the other information. And this is probabilistic. So they may be right, they may not be right. So is it Again, according to the international standards, I don't have an answer to that. And that is why we are essentially working very hard right now to make sure we have the guidance for this next step.
Thank you. Does anybody want to answer the second question?
Yes.
Yes, thank you very much, Zoran.
Yeah, I would just quick reflection on outsourcing data processing, like data centers and everything. Referring back to the data protection legislation, there is one important aspect which requires the authorities, including those that are processing the data on behalf of the authorities, and that is to keep the log of all attempts or any access to personal information from outside or within, and the purpose for which the information is being accessed. In order to provide the tools for the auditors from Data Protection Agency to make sure that the processing is done in compliance with the Data Protection Act. This requirement often has a rather bizarre consequences, and that is that the log database of the agency is much bigger than the actual database of the personal information. This is how important it is for the general public to know that they can trace at every point that their personal data is not being used for non-authorized purposes.
Thank you. Yeah. Other questions? Let's take another round. We don't have a huge amount of time. Yeah. 1, 2, and 3. Okay. So, gentleman with the specs here.
Thank you. Zoran, I wanted to ask, are there any... Sorry, Nick Oakeshott from UNHCR. Zoran, I wanted to ask you, were there any key learning points that you saw for the development of data protection and privacy legislation in the region that you work in? And the reason I asked that is obviously that is something which is being developed in many other states now and being considered. But what were the key learning points from what we've seen? Thanks.
Thank you. Yeah.
Yeah, I think just to take from where Srdjan left, in fact, and what he was just mentioning about the fraud and all that, I think identity established at birth is important. Exactly at the time of birth. And therefore, what we are seeing is more and more integration of national ID and CRVS. In fact, in Africa, almost all southern African countries have integrated civil registration and national ID. And interestingly, the authority which manages civil registration is also the authority which manages the national ID systems. It's Botswana, it's Zimbabwe, or it starts with Zimbabwe and downward, not Zambia. So, and what we are seeing is more and more countries are getting both the functions under one umbrella. Uganda has moved the birth and death registration function under the national ID, newly established national ID management, authority. Kenya has moved its civil registration function from local administration to Ministry of Health after that attack in the shopping mall.
Is there a question?
No, that's what I'm saying. So what I'm trying to say is we are seeing that more and more civil registrars or systems are integrating civil registration under the same authority. So there is a possibility of what Gloria was saying, that the civil registrar would not take it up, but generally the government will try to bring these functions together. That's what I was trying to say.
Okay, thank you. Yeah.
My question is for Philip. Under the Bloomberg Health Data Initiative, the work about legal framework appraisals is very impressive. Is there a movement towards incentivizing death registration, similar to how we incentivize birth registration by immunity, immunization, and school registration?
That is the $64 million question. How to incentivize death registration is a challenge. Beyond removing obstacles and providing services that are closer to where the population is, and talking about the benefits of doing so, actually creating incentives to register a death is a challenging issue. What we're mostly concerned about in the legal and regulatory review is making sure that there are no obstacles, and that, in fact, it is compulsory to do the death registration. But particularly death registration with cause of death is not highly incentivized. But I hear whispering to my left that Claire might want to add a word or two.
No, I think maybe Zoran does.
Yeah, I will respond to the question regarding the data protection. Mainly, the lessons learned and the messages that one can take from this whole process is that for a while, when you don't have universal full coverage, you are primarily concerned to gain universal coverage, and you want to convey the message that it's important for everyone to be enrolled because then everybody will get access to their services. But once this information is at the critical level, the lesson learned is that there is increasing attention from the public in terms of how this information is going to be processed and what happens next. And the introduction of Data Protection Act, Data Protection Authority, had the consequence that the sense of control with the public has been restored. And the sense of transparency, that there is a transparency in how this information is processed, sort of help to advance these systems further. Because you might be familiar in European context, biometric registration for identification document is a no-go area. Public would never agree to it. But if there is an increased confidence in terms of how this information is being processed and not being abused, then the public is more generally willing to accept a certain extended level of processing of personal information.
Yeah, we're nearly out of time. Are there any other urgent questions? If not, I'll ask the panelists, maybe who haven't spoken, to say a few words. Yes, Claire.
Yeah, I just have some final points I would like to emphasise. The SDG agenda is a universal agenda. It's to be applied to everyone, everywhere, in low, middle, high-income nations alike. And I strongly encourage high-income nations as well to be reviewing their CRVS laws and regulatory environment. There are major gaps, for example, in my country, Australia, in Canada. There's a real issue around our Indigenous peoples lacking birth registration, certification, death registration, and then what that means in terms of perpetuating intergenerational invisibility and disadvantage and rights violations. So I'm very keen to monitor and follow what high-income nations are doing too. The second message I want to emphasise is the need for national CRVS laws and regulatory environments, the need for them to be consistent and to harmonise with states' obligations under international human rights laws, and that harmonisation needs to be explicit. We can't rely on explicitness when it comes to de jure law. It needs to be an explicit connection. Thirdly, I would strongly encourage that in terms of preparing, making, implementing, reviewing, evaluating legislation with respect to CRVS systems, that an intersectoral, interdisciplinary and full spectrum approach is taken, and then the strong need for CSOs and communities and community leaders to be involved, owning and leading those processes as well.
Thank you very much, Claire. So we have a remarkable degree of consensus, actually, on the panel, I think. Any final thoughts? We have 2 minutes. So does anybody want to add anything? No?
I just have.
Yes, okay, thank you.
Just a short remark. I don't know if I mentioned while I was carried away giving my presentation, but I brought few copies of this book. They are over there in the corner. Feel free to get a copy for yourself if you have a place in a suitcase.
Okay.
Yeah,
Well, thank you very much. This was a very rich conversation. Thank you. Let's just give the panel a round of applause.